started. Give me just 1 minute to share the screen here. All right, so today we're going to be talking about the difference between multi-member LLCs versus single-member LLCs. Just a few things we're going to discuss today: LLCs versus corporations, what is a charging order as a remedy, seeing if it's the exclusive remedy, why you should ultimately add a minority member, how much of the company you should transfer, any consequences for a minority member, and who the minority member should be. So let's begin with talking about the differences between attacking a corporation versus an LLC. If you had a corporation and you had shares in a corporation, if I sued you and got a judgment against you personally, I could take your shares in the corporation. This means a lot of different things. I could look at the books and records of the corporation. Depending on if you own the majority of the interest in the corporation would determine if I could take control in the corporation, and I could essentially take over all of your shares in your corporation. With the LLC, it's a little bit different. An LLC gets its protection mostly from what's called a charging order. A charging order is a remedy that a creditor has if they sue you personally and they want to try to get at your interest in the LLC. So let's say you get into a car accident. Part of discovery is listing all of your assets. You have to list your interest in that LLC as one of your assets. If someone said, you know what, that's how I want to get paid, let's go after that interest, they would be offered a remedy to get so. What the charging order is if a creditor gets a judgment against you personally and they want to sue it against that LLC, like I said, unlike a corporation, they can't take your interest in the LLC. They can't look at your books and records. They can't take control of the LLC at all. What they can do is stand in your shoes in the event a distribution is issued to you from the LLC. If the LLC issues a distribution, the creditor can stand there and say, now this is mine. So if a creditor were to get a charging order against you and no distributions were made, then the creditor wouldn't get anything. They can't look at the books and records, can't take over the company, they don't own your membership interest. Obviously, you have control over this LLC, so realistically, you just wouldn't make a distribution. Hopefully, the statute of limitations would run up and they would be out of luck for getting anything out of your LLC. So it's important to realize that some states don't have charging order protection. Every state's going to have different laws. If you'd like to look into what states offer different options for charging order, you can go to our website, and we have a whole chart there that lists every state and the remedies that the creditor has against both an LLC as well as a limited partnership. There are some states that don't have charging order protection. Some states provide for charging, Some states provide for charging order protection, but they also provide the creditor the remedy of foreclosure. So that's pretty similar to what we were discussing with the corporation. There are, however, some states that offer charging order as the sole and exclusive remedy. If possible, it's best to use a state that only offers charging order as a remedy. Of course, consult with an attorney to see if you're able to do so. Depending on where you're operating, depending on what you're doing with this LLC, you may not have the flexibility, say, as a holding company or some other non-operating business. If you're able to do so, if you're able to set up your LLC in a state that offers charging order as the sole and exclusive remedy, the expectation and the hope is that if you're ever sued, that state's law would apply. Of course, there's no guarantee, but that's the argument that would be made. So the reason we suggest adding minority interest holder on is that some states have a difference between a multi-member LLC and a single member LLC as to whether that charging order is the exclusive remedy to a creditor. So in Florida, for instance, there were a couple cases that came out and then ultimately the statute was changed that said that if you're a single member LLC and you have a creditor with a judgment, that creditor can treat it like a corporation. They can take your interest in the company, they can look at the books and records and essentially take over. However, if it's a multi-member LLC, they're not permitted to do so. They only have charging order as a remedy. So we always like to be proactive and conservative and suggest that it would be better to add a second owner for a minority interest to your LLC. As I discussed, the preferred route would be to set up your LLC in a state that offers the charging order as an exclusive remedy to both single member and multi-member entities. But like I said, there's no guarantee that that state's laws would apply. There's different states, much like Florida, that say, nope, single member entities are not afforded that same protection. And we want to make sure that we're being conservative and proactive and suggesting that you add that second owner on for minority interest to your LLC. So typically the first question we hear is, well, how much of an interest do I need to give this minority member? You know, I've been working on this company. I really don't want to give anyone, you know, much of a share in my company, let alone any control or liability. We'll get to that. But as far as the interest alone, we understand the hesitation of transferring a large amount of interest in your company to someone else. So there really is no right or wrong answer. Percentage wise, you're probably going to want to go fairly low, certainly because you don't want to transfer over a major chunk of your company to someone else. And also because this is, you know, a high value asset potentially. And depending on what you're going to give to another person, there might be a gift tax return or a much higher valuation. So you would need to consult with an attorney or a CPA to look at the numbers, but you typically want to go 1 to 5%. Obviously, the more the better. With that being said, most people give somewhere between 1 to 5%. Like I said, higher you're willing to go, the better, but of course, keeping in mind potential tax consequences. So speaking of consequences, what are the consequences for the minority member? We've obviously talked about the advantages, but what are the detriments of having this person on your LLC? From a minority member standpoint, they have no liability to anything that happens in the company, and they have no control. So they're not going to be able to manage the company. They're not going to be able to enter into contracts on behalf of the company, and they will have no liability for anything you do in the company. The only thing that's going to happen is that each year, since the company will now be filing a partnership return, they will get a K1 for their proportionate share on the income of the company. So if the company earns $100 of net income a year and your minority interest holder owns 5%, they would get a K1 for $5, and they would have to pay income tax and include that in their return for the $5. Typically, an LLC operating agreement allows you as the manager to determine if distributions are made and whether or not you want to make them proportionately. If everything's going well in life, we do suggest making it proportionate because it provides evidence to a court that it is a fully solid multi-member LLC. If you have someone on there and you're not making any distributions to them, you may have a harder argument that yes, they are actually considered a member and this is a fully solid multi-member LLC. However, even if you choose not to do so, you certainly want to cover whatever their tax burden is going to be for the minority interest holder. As we just discussed, they will be getting that K1 for their proportionate share. So it's important to make sure you're covering whatever that tax burden is going to be. So just to recap, you want to add a minority interest holder to your LLC from anywhere from 1 to 10% on the LLC. It's important to consider both capital contributions and gift tax implications associated with the transfer. Again, that person will get a K1 for their proportionate share of the income. The LLC probably won't be, too high if you keep the value pretty low. You can even go, if you've got a multi-million-dollar company and you're trying to stay under that gift tax threshold, you could do a 0.5%. Or even lower than that, just keeping in mind the higher you're willing to go, the better. It's important to discuss any potential tax consequences with a CPA and or tax attorney when it comes to making that gift. You may also want to discuss that person potentially buying in, making a capital contribution for their interest. The next question we usually get is, who should my minority member be? So ideally, a third party, someone who's not related or remotely related, would be better. So again, it has the appearance of a fully solid multi-member LLC. The closer in relation you are, the less it really looks like a multi-member LLC. For instance, your spouse, you're considered one, they won't count as two or a multi-member, in our opinion, for asset protection purposes, and often not for tax purposes, potentially, but not for asset protection purposes. Children are a possibility, but if you can get more remote, a sibling is better than a child, a friend is better than a sibling. If you're going to add your children, it does make a difference whether they are adults and minors. So that's certainly something that you want to consider. Now, I'd also like to point out that potentially you're setting up a limited partnership or a different kind of entity. Just to speak briefly on the limited partnership, it would be better if that entity was also multi-member for similar reasons. Many states offer charging order as the exclusive remedy for a partnership if they're considered multi-member. Again, a judge is not supposed to treat you and your limited partnership as one entity, but judges can make unilateral decisions all the time. So it's very important that you're just being conservative and proactive when you're doing your planning. For the limited partnership, it's a bit different. This is more of an estate planning tool or a holding company aspect. And because of that, who you should add is a little bit different. Because you are saying that you're doing it for estate planning purposes, children are actually a great option. Anybody that would naturally inherit from you. This is a way that you can say, this is me trying to give to my beneficiaries early on without giving them any sort of control. Because that's the narrative, we do recommend having family members or anyone that would, as I said, normally inherit from you. Keeping in mind, when adding somebody onto your companies, it's very important that you trust them. So although I said an unrelated third party would be much better than a child, a sibling, or a friend, I would certainly want you to choose someone that you're comfortable with. At the end of the day, you are adding them onto a company that you've worked probably very hard to set up, keep your business going. So it's important that you trust this person and you believe they're of good moral character. If you don't have anyone that's non-related that you do trust, and that's often the case, we would much rather you put someone on there that is related that you trust. So I know today's webinar was short and sweet, but you would be surprised how much of a difference this multi-member versus single member distinction can make. So if you have any questions for us, please feel free to submit your questions via email to info@assetprotectionattorneys.com. And if you're interested in hearing us speak or having us come to a group that you're involved in or your place of work, please feel free to reach out. We do lots of speaking engagements, lots of other webinars. If you're not already getting our weekly newsletter, please feel free to reach out. And we will also offer you complimentary copies of our books, as well as a complimentary preliminary consultation. So you can visit assetprotectionattorneys.com and complete that contact form, and someone will reach out to schedule that with you. Thank you as always for watching and connecting with us. Please feel free to reach on to any of our social media to get our weekly blog posts. We've begun doing pressers protection points and giving important pieces of information to help with all of your asset protection needs. We also post bi-weekly blog posts, articles, and different features. So thank you for your time today. If you like, as I said, if you have any questions, please feel free to reach out.